Today's episode is brought to you by Mazars.
SoundCartel.
From SoundCartel, I'm Nicole Goodman, and this is Business Essentials Daily. As a boss, do you contact your employees when they've knocked off from work? Well, soon, new legislation will protect staff who choose to ignore your calls or texts after hours. It's called the Right to Disconnect Law, and although it doesn't come into effect until later this year, it's important you understand and prepare now for those changes. Ryan Price, Head of Content and Training at Employsure, explains the new law to Chris Ashmore.
The federal government has passed some changes to the Fair Work Act that create a new right for employees to refuse to monitor, read or respond to contact or attempted contact from their employer outside of their normal working hours as an employee, unless that refusal is unreasonable. Now, that's a really important caveat there at the end, unless the refusal is unreasonable. The laws also give a list of the things that you have to look at if you are trying to decide whether or not that behaviour or conduct is unreasonable. So that includes things like whether or not the employee is compensated for the time that they're being contacted in, whether they're being paid for that, say as on-call time, or if they're receiving additional overtime or payment in their salary that's made in consideration of that. The reason for the attempted contact. So how serious is the reason? Is it something that is actually timely and urgent and needs responding to right at that moment? The nature of the employee's responsibility or their role. So how senior are they? Are they a manager in your organisation, or are they just a frontline worker or contributor? And also the employee's personal circumstances. What's actually going on in their life that might make it more or less reasonable for them to be picking up the phone at that time? Now, I know there's a lot to unpack there, but basically it means that employees now have a right not to pick up the phone unless it's unreasonable for them not to, or to avoid it. So it really means that employers can still contact their employees outside of working hours, but you're going to need to be mindful about it, and you won't always be able to expect that your employee is going to respond to that contact.
There's a lot of caveats there, and that it can be confusing for business owners, but there's plenty of industries where a boss needs to ring their employees. For example, in retail or hospitality, where there's a shift the next day, employee calls in sick, they've got to find a new shift worker. Can they still do that if it's, say, 8 p.m. and the shift starts at 6 a.m.? Is that doable?
Yeah, absolutely. It's still doable. So I guess that was the case before, and it's still the case now. You can still contact that employee, but there is that caveat, that carve out, that as an employer or business owner, you can always call your employee. You can always reach out to them to offer that shift. You just can't expect that your employee will respond to your attempts to call them in every instance. As a bit of an illustrative example, if I can offer you one. Say if you're in hospitality and you've got a high-paid marketing manager, that person might be expected to field a call about promotions on the weekend because they are in a senior role. They're compensated in consideration of the fact that they need to do that. That's part of their responsibilities in their position. They're receiving a higher salary because of the fact that they are responsible and need to be available for it. But conversely, if you're a fast food employee, you might be reasonably expected to respond to a text message offering you a shift the next day within a reasonable time frame if it fell within your availability, but phone calls might not be as reasonable for that person. So it's about the method of contact and the urgency of it and matching the situation to the responsibility of the employee and the nature of their role.
What if an employee is quite happy for their boss to contact them outside work hours? Is that okay to do so?
Yeah, that's definitely okay, Chris. So really in most circumstances where an employer would want to be contacting their employee, they still can. You can still send that text message, still try to call that employee. It's just the case that you need to keep in mind who you're contacting, why and how, and make sure that it's not something that can wait or should wait until the employee's next at work. If the employee wants to be contacted and it's an established expectation or a norm that you have in the business, then the new laws don't prohibit you or prevent you from attempting that contact. It doesn't stop you from doing that. It just makes it so that the default presumption or the baseline position is that that employee can't be expected to respond to your contact unless it's reasonable, which means that in this case where there's an agreement, it's absolutely going to be reasonable.
And that agreement should really be in writing, shouldn't it?
Yeah, ideally you could have an agreement in writing. There's a few different things that you could potentially do to help you with that. So having negotiated policies and expectations in your business is absolutely one of the things that I'd recommend employers start looking to do.
What happens if a boss continues to insist their employees pick up the phone or reply to texts after hours? Are there penalties?
Well, first it's going to depend on whether the insistence is reasonable or unreasonable in the circumstances, like I said before. But assuming that it was, say, unreasonable insistence by the employer, then let's just say the boss, for example, might be calling the employee 15 times between 10 p.m. and 3 a.m. Might be unreasonable in the circumstances. Then first, what needs to happen is that the employer and employee have to meet to try and resolve the issue at the workplace level. The new legislation actually requires that the parties try to resolve that dispute at that local level before it progresses further. If you meet at the workplace level and you're unable to come to an agreement and resolve the dispute, then either of the parties can make an application to the Fair Work Commission. The key point there is that even the employer can say, I'm not getting anywhere with this employee. I want to make an application to the Commission for this dispute to be decided by them and arbitrated. The Commission can then make an order about what happens from there after they've looked at the whole circumstances. There's a few more bits in there, procedural items like the fact that the Commission needs to look at those questions within 14 days of the application being made. But what happens from there is that the Commission can make an order that would direct either the employer or the employee to do or not do something. So the order can be an order to prevent the employee from unreasonably refusing contact as well. So it can be an order that directs the employer not to contact or the employee to accept the contact. But in our example, say they make an application to prevent the employer from taking disciplinary action or continuing the attempted contact, and the employer then continued to contravene that order and try to contact the employee against the instruction of the Commission, then the Fair Work Commission can actually hand down a fine with a maximum penalty of 60 penalty units, which approximates to about $18,750, thereabouts. So it's interesting to note here, though, that those orders can apply to both sides, and that if an employee received an order to not refuse contact and then continued to refuse contact from the employer, they could be subject to the same fines and penalties. So the legislation cuts both ways, Chris.
Right. It'll be another 6 months before these rules kick in. Is there anything that business owners need to do to prepare for those new rules?
Yeah, absolutely. The first thing that I'd be asking businesses out there to think about doing is setting policies or standards on what kinds of methods of contact will be used and when, and give this guidance to your managers, your shift supervisors, or other staff who might need to contact employees outside of hours for any reason. So that's the very first thing I'd do. In doing that, I'd recommend that employers actually draw a line and say, okay, in this situation, it's a more serious issue. Say there's been a workplace injury or incident, and that's something where I'll need to contact this person outside of working hours, and the method will be telephone. Say if it's I need to replace a shift, then it'll be text message. So you want to balance the method of communication against the seriousness and urgency of the situation and provide training to your staff on that. Another element there that you'd want to look at is consultation with your staff. So actually going out to them, having a conversation with them about this issue and asking them, what is an appropriate method of communication in this instance? Because if you get your staff's buy-in, they're more likely to comply with the policy and have the expectation and standards there agreed amongst your employees. So getting them to indicate their preference for contact is another thing you might want to do. Part of your onboarding process, you could be asking them, if we need to contact you outside of hours for any reason, would you prefer text message, email, or phone? Next, if you have a situation where an employee isn't responding to your communication outside of their working hours, the first thing I'd say is don't jump straight to disciplinary action and ask them why and consider their reasons. Actually have a conversation with the employee in the first instance rather than confrontation, because you don't want to leave yourself exposed to a potential claim or to see this go to the Commission. Don't assume that it was reasonable in all the circumstances to expect them to answer the call without looking at the bigger picture, and make sure you seek advice from a specialist, for example, like Employsure. The next thing I'd say is you could also actually tip the scales more in your favour around the reasonableness of your outside of hours communications by potentially compensating your staff for the fact that they're required to answer their calls outside of hours. So that could be an additional allowance or on-call payment to compensate employees for the requirement to remain available outside of their working hours, which then is one of those factors that the Commission has to take into consideration when they're deciding whether or not that out-of-hours contact is reasonable, Chris. So prepare your managers and supervisors, set your policies up, decide whether you want to do additional payments, and make sure that you've got processes and expectations in place about what your staff will do if an employee objects to that out-of-hours contact.
That was Ryan Price, Head of Content and Training at Employsure. This episode of Business Essentials Daily is produced by the team at SoundCartel. Thanks for listening. I'm Nicole Goodman. We'll bring you more Be Daily tomorrow. Follow at BE Daily Podcast across social media and head to bedaily.com.au for more from the Business Essentials Daily podcast. SoundCartel. This episode was brought to you by Mazars. To find out more, visit mazars.com.au. That's mazars.com.au.